Hi everyone tuning into this video. My name is Luke. I'll first talk about illegality and the consequences of illegality pre-Patel against Mirza. Then I'll head on to explore the new approach in Patel's case. Illegality in contract law happens when there is a transgression of statute, common law, public policy, criminal law, and civil law. Illegality is found either in the formation or performance of a contract. Therefore, if a court determines that the contract is illegal, it becomes void and unenforceable. Besides that, an argument of illegality in a contract can also be used as a defense to breach of contract. In Malaysia, the provision for illegality is found in Section 24 of Contract Act 1950 as defined by Pei Sui Chin in the case of Sabah Bumi against Dato' Yap Pak Leong. The defense of illegality has its foundation in this very famous case, the case of Holman against Johnson, where Lord Mansfield mentioned in an obiter, stating that the principle of public policy is this: ex dolo malo non orito actio, which means that no court will lend its aid to a man who finds his cause of action on an immoral or an illegal act. Therefore, if the plaintiff's cause of action appears to arise ex turpi causa, the court says that he has no right to be assisted. Thus, the courts develop a rule-based approach in determining the outcome of a claim tainted by illegality. There are essentially two general rules pre-Patel against Mirza. Firstly, the court will never enforce illegal contract and is inflexible in nature. Secondly, the court would generally not permit recovery of benefits conferred under illegal contract unless it falls within the three exceptions. Firstly, where the claimant is not in peri delicto, which means not equally at fault. Secondly, locus poenitio, timely withdrawal before illegal purpose is carried out. And lastly, no reliance on the illegality to prove a right to the property sought to be recovered. In the case of Tinsley, the courts held that since Milligan did not rely on illegality, she is entitled to her claim. However, the landmark case of Patel against Mirza made a drastic change to the standing of the law as rule-based approach was rejected and flexible multifactorial public policy consideration was adopted. The facts of the case are as such: Patel had given Mirza 620,000 to bet on a bank share price using insider information. Both knew that this agreement amounted to an illegal act, contrary to Section 53 of the Criminal Justice Act. However, as the insider information did not materialize, the bet could not be placed. Patel then sought to recover the money from Mirza, claiming a breach of contract by Mirza and unjust enrichment. Therefore, the issue set forth before the UK Supreme Court was whether the maxim in Holman against Johnson, ex dolo malo non orito actio, automatically precluded a party to a contract tainted by illegality from recovering the money he had paid under the contract. The majority, 5 out of 9 law lords, held that Patel was successful in his claim to recover the money despite having relied on illegality as a defense. Thus, the majority's new approach has laid down several key principles which was subsequently affirmed by the Malaysian case of Pang Man Chong and another against Chong Hui Chan. First key principle, the reliance rule in Tinsley should no longer be followed. The second key principle, a claimant will no longer be prevented from enforcing his claim to property because it was paid under an illegal act, unless, of course, allowing his claim would be contrary to public policy and disproportionate. Therefore, in deciding whether to allow a claim for recovering money paid under an illegal contract, courts must now look at public policy on whether allowing the claim will be harmful to the integrity of the legal system by taking into account the trio of consideration. The first consideration, whether the purpose of the prohibition that had been transgressed would be enhanced by denying the claim. Second consideration, whether denying the claim might have an impact on another relevant public policy. And third consideration, whether denying the claim would be a proportionate response to the illegality. In regards to the proportionality, Lord Towson also suggested a range of factors such as seriousness of illegality, centrality of illegality, whether the illegality was intentional, and whether there was disparity in the parties' respective culpability. Now, my teammates will be examining the new approach further and discuss whether the new approach had clarified or confuse the law in this aspect. Thank you.
My name is Pin Hao, and I will discuss about the benefit of the new approach. The Supreme Court decision in Patel against Mirza established a new approach that wipes the state clean of the existing rule of no recovery and the exceptions to the rule. Justice McLaughlin had influentially expressed it in the Supreme Court of Canada in the case of Hall against Hibbert that the new approach can maintain the integrity of the legal system as a few consideration was specified as being relevant in achieving that high-level goal. And these considerations were the purpose of the illegality in question, any conflicting relevant policies, and the need to avoid a result that was disproportionate. The new approach can also be said is in favor of what appears to be a broader right to recovery. Lord Towson sought to develop the law in a different direction by holding that a claimant who satisfies the ordinary requirements of a claim in unjust enrichment will not prima facie be debarred from recovering money paid or transferred simply because the consideration which has failed was an unlawful consideration. In this way, the majority sought to free the law from what it saw as the arbitrary consequences which flowed from the existing common law, in particular the rule that a claimant can recover money paid or property transferred under an illegal contract if he can establish his right to the money or the property transferred without relying upon the illegal nature of the contract. The recognition of a wider right to recover benefits conferred was held not to undermine the policy behind the rule, which rendered the contract illegal because, in granting a right of recovery, the court was not seeking to enforce the contract, nor was the claimant seeking to profit from the illegality. On the contrary, the aim was to put the parties back into the position which they would have been in had no illegal transaction ever been entered into. The right to recover benefits or property transferred under an illegal contract appears to have been widened. Supreme Court in Patel has created the potential widening of the rights to recover benefits or property transferred under an illegal contract so as to restore the parties to the position they were in prior to entry into the illegal contract. As for the Malaysian position, the decision in the case of Patel against Mirza was approved in its entirety in the federal court in the case of Liputan Simfoni Sendirian Berhad against Pembangunan Orchid Desa Sendirian Berhad. This shift in legal policy was to take into consideration the public interest in the integrity and inconsistency of the legal system, as per Harminder Singh, Justice Court of Appeal in the Court of Appeal case of Pang Mun Chong and another against Chong Hui Chan. What this means is that when it comes to illegality in contracts today, the court should no longer concern itself with the rigid presence of any illegal elements and how much of a centerpiece it is in a claim, but instead should firstly consider the wider effects of the illegality and the proportionality of the illegality in respect of the claim before determining whether a contract should be voided for the same or not. This further confirms that the new approach promotes widening of the right to recover benefits or property transferred under an illegal contract. However, it can also be seen that the minorities who are Lord Neuberger, Lord Mans, Lord Clark, and Lord Sumption rejected this new approach. Their argument was that Lord Towson's range of factors approach converted a legal principle into an exercise of discretion and required the courts to make valuable judgments about the respective claims of the public interest and each of the parties. Besides that, they argued that the change was unjustified and was not necessary to achieve substantial justice in most cases because it would lead to complexity, uncertainty, arbitrariness, and a lack of transparency. Now my groupmate will talk about the disadvantage of the new approach.
Hello, my name is Jacqueline and I will be elaborating on the uncertainty laid down in Patel and Misa. Although the new approach has proved to have its advantages, there still lies an undercurrent of uncertainty within its mechanism. Strong evidence may be seen where the intervention of Parliament is limited as the common law principles remain dominant in the realm of illegality. By extension, it was also forcefully argued that it is not for the Parliament to define arbitrary, unjust and disproportionate. Perhaps this may contradict the doctrine of parliamentary sovereignty, limiting its powers or breathing new life into the laws of illegality. The issue that arises now may be that the judiciary has granted themselves great discretionary powers within the darkness that shadows illegality. From a critical perspective, Fellows argues in parallel with the muddy waters manifested by the Supreme Court. The broad range of factors laid down in Patel and Mirza grants the judiciary much arbitrary power in deciding upon illegality. By extension, Fellows alleges that a degree of uncertainty may be a recipe for disaster upon future cases. This scenario may be detrimental to the development of the law, increasing pressure on the legislature that, to a certain extent, has their hands tied in the laws of illegality. It should also be noted that public policy remains a facet of illegality. In line with the new approach, public policy lacks a clear definition. Further, public policy has survived through much flexibility as considered by the judiciary. In regards to public policy, it grants a great extent of arbitrary power to the courts, once again leaving room for uncertainty. Where public policy has proven capable of surviving changes, it may act in a stark contrast with the doctrine of judicial precedent. Thus, public policy was argued to pose as a lacuna in the legal system, painting an unfavorable scenario in close relations to the new approach. Although it is submitted that the courts now have much arbitrary power in deliberating upon matters concerning illegality, the Law Commission assumed that illegality would now be decided upon open and detailed reasoning. Public policy was asserted to be essential to the area of illegality, as it would only act as a shield as well as a cause of action where it was in the interest of public policy. Based on an evaluative standpoint, the uncertainty encompassed in the new approach was also clearly described by Lord Mans in Patel and Misa as to be indefinite. Peter Goldsmith further supports the argument by describing the set of rules to be highly fluid. In addition, Lim suggests that the proportionality element in the new approach may be very uncertain due to its intricacy. However, whether or not certainty is vital in the realm of illegality is debatable. This may be highlighted in Lord Tolson's judgment, stating that the laws of illegality have always been uncertain and there have been no dire issues in relation to other jurisdictions who adopt the flexible approach. Further, even if uncertainty played a significant factor, Hui pens that the new approach, just uncertainty, would be outweighed by the justice that may be derived from the new approach. Further, the decision of the English Supreme Court has not been confined within English courts, but it has also grounded its place in the Malaysian legal system. Evidence may be seen in Sawan Singh, Kundan Singh, and Aminah Fauza, where it was clearly contended by Justice Azizul Azmi Adnan that Section 24, subsection E of the Contracts Act 1950 may be adapted to adopt the new approach under Patel and Mirza. In terms of coming to his decision, he took into account public policy which is in line with the revolutionary law after Patel and Mirza as we know today. However, even in Malaysia, it was argued by Tan that public policy has no explicit definition in the Contracts Act 1950, nor in any other written law. Hence, even where Patel and Mirza were to be applied and consolidated with the Malaysian Contracts Act, the approach still remains uncertain in both the jurisdictions till this day. Despite Lord Tolson's view of the new approach, it may be debated that uncertainty is a factor that should be scrutinized in the eyes of the law. Similarly to parties trying to escape from a bad bargain in Arnold and Britton due to the uncertainty in interpreting the law, its concept may be applied in the laws of illegality, where parties may try to claim for losses under the broad definition of the new approach. In contrast to the usual practice of the European courts, both English and Malaysian courts are bound by the doctrine of judicial precedent. As proven in the earlier discussion, where the new approach operates with uncertainty, Barros contends that the best way to apply the laws would be by way of implementing well-defined rules. Perhaps it may be suggested that the approach laid down in Patel and Misa should not be followed. It is also submitted that the law in Patel and Mirza remains ambiguous. Hence, the new approach remains uncertain and has failed to clarify the laws encompassing illegality. Thank you for your attention, and the next disadvantage will be discussed by Clifford.
I'm Clifford Teo. The next disadvantage is regarding the windfall and severity issues. The discretion allowed into the law of illegality does not resolve the windfall problems. Under the previous approach, which is the rule-based approach, in Holman's case, it was held that no court will lend its aid to a man who finds his claim on an illegal act. This signifies the reliance and repentance principle, which prevents a party from making use of an illegal act to form a claim. However, in the current approach, the status of the locus penitentiae principle is unclear. While the reliance principle of Tinsley against Milligan was rejected by the majority, only Lord Towson made any reference to the locus penitentiae principle, and that was simply to regard it as irrelevant. In Chung Ting Pui against Lee Pak Sao, the court in this case referred to the principle outlined in the judgment in Patel against Mirza, thus excluding any application of the locus penitentiae doctrine as it does not fit the framework suggested by Lord Towson. Therefore, under this discretionary approach, there are likely three outcomes. Based on Lord Towson's approach, the first outcome is the illegality does not offend and or can be reconciled with the underlying policies, and the claim will be allowed. Second, the illegality offends the underlying policies, but the claim is allowed because rejecting it would cause a disproportionate result. Third, the illegality opposes the underlying policies and bearing the claim is proportionate. The problem here lies with the possibility of outcome 2 and outcome 3 happening as the result would be undesirable. The second outcome allows the claimant to profit from his own wrongs, while the third outcome leads to an unjust benefit to the defendant. Thus, this would disregard the point that one should not profit from his own wrongdoing. Although the trio of considerations may be flexible, the difficulty in applying the principle remains an underlying problem. The fact that none of the lords sought to provide or offer guidance as to how illegality will be applied in practice when considering the relevant policies is worrisome. Lord Mann's critique, this approach introduces entirely novel dimensions into any issues of illegality because courts have to refer to a widely spread melange of ingredients about the overall merits or strengths in a highly unspecific non-legal sense of the respective claims of the public interest and the parties. Lord Towson concluded in Tinsley against Milligan that it would be disproportionate to have prevented Milligan from enforcing her equitable interest in the property and to have Tinsley unjustly enriched. However, he held that it may be different according to the scenarios, and the court may not enforce a claimant's title, for example, where it will assist the claimant in a drug trafficking operation. Lord Towson once again did not lay down a distinction or further elaborate between these two examples. It is also unclear why he believed that it would be disproportionate for Tinsley to keep the property solely. It is a concerning affair considering the landmark case that sets the rules for disputes on illegality gives us no new grounds on which to think that transactions involving acquisition of illegal drugs can be enforced through the courts. Lord Neuberger, who supported the range of factors approach, claims that the transactions with direct criminal objectives could not be enforced, as civil courts could not undermine the prescription of criminal law. Nevertheless, there will still be doubts whether a court would treat a drug dealer claimant with the same leniency as in Patel. However, there are recent cases that indicate a good sign of new approach, which an illegality defense can arise, such as in Singularis Holdings against Daiwa Capital's Market, which involves running a company, and Day against Womble Bond Dickinson, which relates to abusive litigation. In a way, it is arguable that public policy consideration can benefit the system, as it can lead to different outcomes, although there is no proper guidelines on the application of the approach. Now, I will pass to Yisian to talk further. Thank you.
My name is Yisian, and following my teammates' discussion, it is important that the theoretical foundations for illegality are clear, so that reforms can be assessed. Traditionally, there are two normative justifications behind the doctrine: that one should not profit from his own wrongdoing, and that the law should not be self-defeating. However, in Patel against Mirza, Lord Tolson disregarded both of them. In his view, the normative issue in cases tainted by illegality is whether allowing recovery for something illegal produces disharmony in the law. It will be argued that the former two rationales should not be rejected. The illegality doctrine, as deduced by the Holman Rule, is that no court will lend its aid to a man who finds his claim on an illegal act. This underscores the reliance and repentance principles. Parties cannot use illegality to establish a claim. At common law, this is reflected in the maxim impari delicto partial est conditio defentis, where both parties are at fault. The defendant's position is stronger because the court will not assist the plaintiff. In equity, this is reflected in the he who comes to equity must come with clean hands maxim, which suggests that a court should not assist the party seeking relief upon evidence of illegality, no matter how meritorious the case is. However, its precise meaning is open to various interpretations. Unsurprisingly, the majority in Tinsley against Milligan blunted its full force, viewing it as too rigid. In regards of the first normative rationale, Lord Tolson argued that this position is very generic and does not of itself provide any sure guidance to the solution of a problem in any particular case. Following that, he also drew support from Hall against Herbert, believing that it may have the undesirable effect of tempting judges to focus on whether the plaintiff is getting something out of the wrongdoing, rather than on the discussion whether allowing recovery for something which was illegal produces inconsistency as well as disharmony in the law, and so cause damage to the integrity of the legal system. Accordingly, the better view is that the first rationale is valid, and a fortiori so is the second. In Lord Danning's words in Chater against Chater, he cannot use the process of the courts to get the best of both worlds, to achieve his fraudulent purpose and also his property back. The rejected rationales by Lord Tolson do not necessarily upset or create a disharmony in the law per se, but may do so where both parties are at fault, and preventing one party from profiting means an illegal gain to the other. In such cases, the need to maintain the integrity of the legal system is relevant. This debate is essentially whether a discretion-based approach that can cater to the nuances of individual cases is better, or whether a rule-based approach offering certainty and reliability is better. Lord Sumption in particular was very critical of the principled approach, where it is suggested that the exercise of discretionary decision by the courts will lead to a censor's decision-making and will degenerate into an instinctive judicial preference of one party over the other. It can be submitted that the Supreme Court was essentially replacing a bad old rule with a bad new one. Therefore, it can be humbly argued that the rule-based approach is better because it is normative and can resolve the problems of reliance and repentance principles, whereas the discretionary approach ignores the wrongly rejected rationales and fails to address some criticisms of the reliance principle. Although there are areas of law where discretion is more desirable, it will be shown that the discretion, as formulated in our discussion by my teammates on Patel against Mirza, creates more problems than it solves due to a lack of guidance and certainty. With our in-depth discussion, we feel that the minorities rule-based approach in Patel against Mirza should be welcomed as the forward-looking approach to illegality, because it resolves the problems of the reliance and repentance principles, which the discretionary trio of considerations cannot do, because it ignores the windfall and inadequately addresses the severity problems. In our view, the new approach as formulated in Patel against Mirza has not effectively settled nor clarified the law in this area. Both of the approaches, as scrutinized and explored throughout the development on illegality, will always ignite debates and criticisms in both English and Malaysian law, as there is no one perfect way to counter each case in one uniform manner. It may be doable to observe the courts utilizing the approaches interchangeably, according to the needs of the case, while incorporating a more detailed guidelines, for example as set out by Clark J's extensive list of principal criteria. With that, we end our discussion on this topic. Thank you for watching.